and I welcome you all to the 258th Saturday webinar organized by Manage CIA, the Center of Innovation and Agripreneurship under the National Institute of Agriculture Extension Management Manage. At Manage CIA, our mission is to promote innovation and support agri-entrepreneurs by providing mentoring, capacity building, and incubation services, helping startups turn their idea into successful venture in the agriculture sector. So today's session is focused on very important topic for all the startups, protecting your innovation, intellectual property rights for startups. Intellectual property is the key to safeguard your innovation and ensuring your startup's competitive advantage. So talk on this topic and share their expertise with us. We have two experts today. So without further delay, let's start the session by inviting our first speaker. To introduce him, I would like to invite Mr. Arvind.
Thank you, Sonam. So, hello everyone. This is Arvind Singh Rao working at Manage CA Hyderabad, and it is my honor to invite Mr. Srinivas Medipati, a Managing Director of EVA Patent Services and EVA Quality Certification Services. He is also President of Educational Society for Intellectual Property Rights. He is an IPR attorney and patent expert with over 70 years of experience and supporting more than 5,000 businesses in patent, trademark, and IP strategy services. He is also a certified Indian patent agent and IRCA certified lead auditor with rich expertise in helping startups to protect their idea and build strong IP portfolios. With this brief introduction of sir, I would like to hand over this session to you. Over to you, sir.
Very good morning, everyone. Thanks for the opportunity given by Manage. Myself, Srinivas Madhipati, patent attorney with the firm EVA Patent Services based in Hyderabad. So today we are going to explore the exciting intersection of innovation and intellectual property rights in the context of agriculture. When we think of innovation, Sonam, can you please share the slide?
Yes, sir. Yes, sir.
Thank you. When we think of innovation, we often imagine technology startups or space exploration, but agriculture has always been a hub of innovation. From the introduction of the plow thousands of years ago to today's precision farming using drones and artificial intelligence, innovation is what drives agriculture forward. In India, agriculture is not just a livelihood, but the backbone of our economy. Farmers and agri entrepreneurs are constantly looking for ways to produce more using fewer resources and in an environmentally sustainable manner. That is where innovation, I believe mainly, that is where innovation plays a crucial role. And without IPR protection, many of these innovations risk being copied without credit or reward. Today, let's see how different types of innovation, it can be incremental, disruptive, radical, and other kinds fit into agriculture, and how intellectual property secures their value. Mainly incremental innovations, like if you see like idea and innovation, like normally we as patent attorneys or patent act says, ideas cannot be patented or ideas cannot be copyrighted. Why? Because idea is a thought or suggestion for a new solution. I'll give an example in the next slide. But innovation is what actually the idea, the how we implement it. See, the process of introducing new or improved ideas or products or methods based on the idea we have is the innovation. So innovations can be protected, not the ideas themselves. So on second slide. Yeah, next slide. So incremental innovation means small but meaningful improvements. In agriculture, it often addresses everyday pain points for farmers. For example, the remotely operable multifunction agriculture apparatus, like we have a patent grant for this just 3-4 years back, but it's not a radical innovation. It's an amalgamation of the known things in the field of agriculture, in the kind like agriculture is done traditionally. So traditionally, a farmer might need separate machines or heavy labor for plowing, spraying, or sowing. Sonam, can you please go to the next slide? We'll come back again. Next. Even next. Next. So this is what I'm talking about. We got a patent grant for a startup in Hyderabad. So traditionally, a farmer might need separate machines or heavy labor for plowing, spraying, or sowing. So this innovation combines all these into one device or one apparatus that can be operated remotely, saving time, labor, and cost. So we got an objection, or we got multiple objections during the prosecution of this application, saying like these are all known, like a tool for plowing, a tool for sowing, or a tool for harvesting is all known. But combinedly on a platform, and that platform can actually be operated remotely. For example, maybe not possible in all the cases in Indian agriculture, but combinedly, when we see which can be operated remotely, so this been granted as an incremental innovation. Sonam, can you come back? Yeah, next slide. So these are the we can divide innovation into incremental innovation, and some are disruptive innovations, radical innovations, and architectural innovations. Incremental innovations are which are known in the market and been improved so that they are more effective or more useful. And when we talk about disruptive innovations, like new technology itself, like the AI that we are actually integrating in all the machines now. And what are radical innovations? Radical innovations are which change the market dynamics, and architectural innovations are nothing but which creates new market for themselves. So we'll see at least one or two examples of each. Sonam. Yeah. So I'm giving one more example of incremental innovation here. So which is an improved locking or reinforcement system for irrigation pipes and greenhouse farms or greenhouse frames. So these locking systems, there are locking systems, and recently also we are working on one of the invention which greenhouses are known how the removing or maybe the cover removing of the greenhouse for the need of different environments. So which is known with pulley and pulley mechanism. So been altered or improved so that like it is more efficient and easy to operate. So that kind of innovation can be put as incremental innovation. Next slide, Sonam. And this is one more example, like we had a patent grant for something kind of something called a cooling helmet, so which is actually directed and created for traffic police or maybe industrial purposes by a startup here in Hyderabad. And to an extension, they also created a cooling jacket. So they have seen this problem of actually the traffic police or the riders, the bike riders having this issue, or maybe industrial, the hot environmental places like furnaces or maybe boilers where like people work near to it. So they felt there is a need, and they developed something like this with a battery pack on top of or back side of the wearer. And why don't we have an improved system where like a wearable cooling helmet and jacket designed for farmers working long hours in hot fields? So this could be an incremental innovation adapted to our purpose or this application, agriculture application. Next slide, Sonam. And this we already saw. So this is something like amalgamation of known things, but yes, there is an improvement when it is seen as remotely operated and efficiently operated by a fixed setup to a particular field. Next slide, Son. So if you take an example of disruptive innovation, so disruptive innovation, as briefly told in the previous slide, disruptive innovation changes the way things are done and often replaces older practices. So in agriculture, one of the best examples is the robotic harvesting arm. I know like there are harvesters erstwhile not in India, but they are very big. And if you think of a robotic harvesting arm for harvesting tomatoes, or maybe the image shown in the next slide. So for some fruits. So today crops like strawberries, grapes, or tomatoes require delicate hand picking. So labor shortages are making this increasingly difficult. So a robotic arm equipped with AI and sensors can gently pick fruits without bruising them, ensuring quality and reducing dependency on manual labor. It could be a disruptive innovation. So another example is agri-mobility vehicles. Next slide, Sonu. Agri-mobility vehicles, instead of traditional bullock carts or expensive tractors, innovators are building lightweight, stable electric vehicles that can navigate rough farmlands. These vehicles are cost-effective, environmentally friendly, and accessible to small farmers. So disruptive innovations in agriculture often de, uh, democratize technology, making sophisticated solutions available even to small farmers and completely transforming old practices. So we'll take an example of radical innovation. So radical innovation goes beyond improving or replacing. So it introduces a completely new way of thinking. Consider the AI-driven soil microbiome analyzer. So which a startup actually developed it a couple of years back. And farmers often struggle to understand soil health and apply generic fertilizers. But this system analyzes microorganisms in the soil, giving a detailed profile and suggesting exactly what nutrients are needed and in what quantity and what stage. This is highly personalized farming, ensuring better yields with less wastage. So such radical innovations may take time to develop and adopt, but once they do, they can redefine the entire agricultural landscape. So they move us towards the dream of precision farming, where every decision from sowing to harvesting is backed by science and data. Next slide, Sonu. So we till now, like we briefly known like kinds of innovation and how they could actually change today's agriculture in India. So what if like once an idea has been conceived and it has been it should be tested for suitability as a product or process. So what is prototype and process innovation? So prototype innovation means creating models or the minimum viable products and to test new ideas. For example, a 3D printed drone for agri surveillance. So we know drones, but to we have an idea of actually developing a drone for some purpose within the agriculture, but we are not sure like whether to buy it and test it or build it and test it. So why don't we print it and test it? So this is the way like the prototyping should be done with the technology and the resources that we are having now. So this allows innovators to cheaply and quickly test whether drones can effectively detect crop stress, pest infestations, or water shortages before investing in full-scale production. So process innovation, on the other hand, is about improving existing systems. A classic case is the AI-based irrigation optimization. Instead of following a fixed irrigation schedule, sensors in the field gather soil moisture and weather data. AI then decides when and how much to irrigate. This saves water, improves crop quality, and reduces costs. Prototype and process innovations validate ideas, cut costs, and reduce risk, helping farmers adopt technology with confidence. Next slide, Sonam. So now we are actually going to know about what is intellectual property. So now that we have seen innovation, the next question is, how do we protect it? Intellectual property, or IP, refers to creations of the human mind that are given legal protection. In agriculture, this can mean inventions like machinery, trademarks for farm brands, copyrights for training materials, industrial designs for product appearance, and geographical indications for crops unique to regions. Next slide. So think of it as a safety fence around your innovation. Without IP protection, anyone could copy your idea. So with the IP, you get recognition, exclusivity, and commercial value. And if you see the types of IP rights, there are several categories of intellectual property rights. So the main one, which we hear mostly, are the patents. So patents protect inventions such as a new irrigation device, an organic pesticide, or an automated crop harvester. So the technology part, or the way the technology is used, so both are actually protected under patents. And trademarks, so trademarks protect brand names and logos, like the brand of a dairy cooperative or an organic rice company. So these names and logos can be protected under trademarks. And the next important one is the industrial designs. So industrial designs protect the shape and appearance of machinery or packaging. For instance, a unique fertilizers sprayer design, so can be industrial design protected. We call industrial design registration, and in some countries they call design patents also the same. So which actually protects the appearance of the product or the packaging. And the next important one is copyrights. So copyright protect creative works like agriculture training manuals, software and mobile applications, or the other artistic works or the literature work which is associated with the product or maybe selling of the product. And very importantly, so the other aspect is geographical indications. Though geographical indications are not been awarded or maybe granted to one single person or an entity, so it protects strongly linked to regions. The products protected, I mean the products which are linked to regions like basmati rice, Darjeeling tea, or the Alfonso mango. Recently, we filed an application for one of the sweet from East Godavari, so which is known with the region. So that is Tapeswaram Kaja. And we now are actually working on filing an application for Nujuvidu Chinnarasalu, the mango variant from Krishna district of Andhra Pradesh. Likewise, each of these serves as a unique role in securing agricultural innovations and ensuring they generate value for the rightful owners. Next slide, Sony. And how to acquire these rights? Acquiring rights requires knowing the correct legal path, where like patents must go through a filing, an examination and a grant process, and even after grant, they should be renewed yearly from the third year of the patent application till 20 years, which is its validity. And trademarks can be acquired through use in commercial and also registration. Like trademarks is something like there is no need like we have to file when we started using. but it is always safe to file when we started using or before start to use. But trademarks can be filed after some years of usage also by claiming the previous usage. So all that we have to show is the proof of usage along with the application or during the prosecution of the application. And copyrights arise automatically upon creation. So Copyright Act says like registration is not mandatory. So copyright arise automatically upon creation, but registration provides legal strength. And again, GIs are filed collectively. So means like it is known already. It has been used by a group of people from a region from years together, and this can be filed now or anytime to get a registration. So GIs are filed collectively by producers or an association of producers or farmers, and innovators must form an association and then file an application. So combinedly, all these kinds, patents, trademarks, copyrights, or GIs. So farmers and innovators must understand IP is not automatic. You must take the right steps to secure your rights. Next slide, Sonu. And what are patents and patentability? For an invention to be patentable, it must be new, means it should not already exist in the public domain. It should be useful, means it must have a practical application, and it should be non-obvious, means it should not be a simple extension of what already exists. So these are the three criteria where patent office during the examination sees or examines the application that we submit. And the application means we won't be sending the prototype or the MVP to patent office for examination. So it is on paper, means like the draft that we submit along with the patent application, the specification that we submit and the drawings we submit. So they'll examine the specification, the contents of the specification and the drawings when compared with the existing or already published materials. It can be patent publications or non-patent publications. They can be videos or some company's product brochure or product display somewhere. They consider everything. So not only the patent publications in the patent journals or the patent databases. Next slide, Sonu. So what are all the inventions patentable? So we are talking about now utility patents. So what are all the inventions that can be patentable? So as said, new, useful, and not obvious. And apart from these three criteria, so there is one more criteria which is the subject matter is patentable subject matter. Means there is a restriction under class 3 of the Patent Act where like class 3 defines different different scenarios or different aspects which cannot be patented. So that we will see like 3 or 4 examples which are the key subclasses of the section 3 will explore. And in agriculture, so it should fall into categories like process, machine, composition, or manufacture. So these are patentable subject matters in terms of the categories. Like a process can be patented, machine itself can be patented, its technology. The composition of matter can be patented, or a manufacturing method also can be patented, not the method of doing agriculture. This is very important. So section 3 defines in one of its subsection. So it cannot be patented. I mean, a method of agriculture or doing agriculture cannot be patented. Only the method of manufacturing of a product or packaging of a product or the composition with its process of making uh, that could be a liquid fertilizer or a solid fertilizer or a pesticide. These kinds can be patented. A machine itself can be patented. So in agriculture, this could be a new irrigation device which can be patented, a novel seed treatment process which can be patented, or a solar powered sprayer can be patented where like the traditional sprayer been improved or incremented with innovation. So that can be patented. Again, it should not be obvious, or it should not be already existing elsewhere worldwide. So if it is new, then yes, it can be patented. However, these exclusions exist, like Section 3 and some other exclusions exist. You cannot patent perpetual motion machines, like I'll show in the next slide. Sonam, can you please? So you cannot patent perpetual motion machines. Next slide. Next one. I think like, is it the right way? I mean, can you please further go? Next slide. Yeah. So we cannot patent perpetual motion machines like one shown here. So traditional knowledge, like traditional knowledge can also be patented, cannot be patented. So this perpetual machine under Section 3A or anything like this. So frivolous, these are called frivolous inventions. So which are contrary to well established natural laws. So these machines that gives more than 100% performance or claim of giving more than 100% performance, which is not possible otherwise as per natural law. So are treated as perpetual machines and rejected for patent grant. Next slide, Sonam. Or can we go the slide before, 19th slide? Yes. So this is the life cycle of a patent application. So it always starts with a patentability research or a prior art research by the inventors or the patent agent or the patent services provider. So why? Because it is always recommended to know whether it is patentable or not before actually spending a lot of time and cost. So it is always better, like if we have a search connected by a professional or by yourself also, to see whether your invention is patentable or not when compared with all these three criteria of new, usefulness, and non-obviousness. And then we proceed with the drafting of application, which can be a provisional specification if the invention is not completely ready and the inventors are not sure of whether to claim a particular aspect before testing or before actually prototyping it. Then in that case, like we can start the application as provisional application, means we'll get a patent application number and patent pending status with a patent application date. Means from that date, like within 12 months, we can update the application with complete specification. And then as per publication and examination, it can be early examination or regular examination. We can ask for an examination, and then only the patent office, after the filing of request for examination, the patent office actually takes the application for consideration, I mean examination, and then they issue an examination report. They first publish, and then they take this request for examination, and then they examine, and then they'll issue a first examination report, which can be an acceptance also, or maybe with some objections, giving the applicant 6 months time to reply. If the applicant replies within that 6 months by satisfactorily giving the differentiation between the citation that the patent examiner cited, then it proceeds to grant. After grant, from the third year, so the patent need to be renewed. Then only the patent will be active. Though it is granted, if it is not renewed, so it will be lapsed or seized. The patent application fee, the government fee for a startup, small entity, or a natural person, which can be multiple individuals or combination of an individual person or the entity. But if the entity is a small entity or a startup, then the application fees is 1,600, which is only for the filing of the application. And apart from that, if the application need to be published early by patent office, there should be, I mean, there is a separate request need to be made with Form 9 with fee 2,500. And the request for examination is 4,000, and request for early examination is early examination is an additional of 4,000, which means like request for early examination will be 4 plus 4, 8,000. So in total, the application fee asking for examination, early examination, it is approximately 12,100 for a natural person or a startup or a small entity. And I want to mention here like manage or maybe some incubation centers which are having that IP facilitation, and also we as patent agents, all the patent agents are eligible to help startups to file patent applications without actually charging our professional fee under different schemes, like one under the MSME IP facilitation center scheme, and the other one is like scheme for IP protection for startups, so which is a SIPP scheme. And in different states also there are different schemes under the technology. The TSIC means the WIPO's TSIC scheme, which is again here in Telangana State Innovation Council, and the NRDC center we have at Vizag, which are the nodal offices to give an approval for a patent agent to help a startup or an individual, so that like you only need to have to pay the government fees, and the professional fee will be paid by the government schemes to the patent agents. So this is one very important thing. This is also there for the trademarks, and this is also there for the designs. That means like you are only have to plan your government phases. You have to identify the inventions within your startup or your journey of agripreneurship, and then you can actually get these filings done as well, the prosecution done by the agents under the schemes. Next slide, Sonu. Next one. So we have seen section 3A and this is section 3B. So commercial exploitation or primary use of inventions, which is contrary to public order or morality, is also restricted. So a patent will not be granted for certain things, though they are new, which if the patent office feels like they'll be misused. Like we have seen one example in the recent movie Coolie, like the chair which um, the lead role develops as an invention for a particular purpose, but the patent office, it is shown in the movie that patent office rejected the invention, granting a patent because it can be misused. So certain things, even it can be in agriculture also, not only in other technologies or maybe in other fields. In the agriculture also, if the patent office feels like or there is a very chance that it can be misused by by social elements, anti-social elements, then in that case, like a patent can be rejected under section 3B. So this is also very important. Once in a while, we get these examples, but it is also very important. The patent office sees like whether this invention can be used in a positive way or negative way under this section 3B. Next slide, Sonu. So this is important class, a subclass under the section 3, section 3P, so which deals with inventions which are traditional knowledge or an aggregation or duplication of known properties of traditionally known component or components. So it cannot be only the food ingredient or the composition which is known, but the technologies also, traditional way of doing things, even mainly in agriculture. And if some applicant develops a product or a device which replicates the steps of uh, doing agriculture or a traditional process in agriculture, then that device itself, because like it is having, or the patent application is claiming those steps along with the device working, then those claims will be rejected under section 3P. So this is a very uh, important thing to know. So these are I'm discussing three sections, but there is another subsection I already told, like which the method of agriculture itself cannot be claimed, and if it is claimed, like it will be rejected. Yeah. So Sorry, I'm actually bothering you. I see like now I'm also allowed to change this slide. Yeah, thank you. So, and the next one is important subsection is section 3K, so which is related to computer-related inventions. Why I put in this session is this is very important because the upcoming startups in agri-tech are all actually thinking of upgrading the existing systems or using AI or the data available already. They want to use the data. So in there, like we see some kind of an invention coming up, and which again under section 3K of Indian Patent Act, so comes under computer related invention, and there is a separate guideline for computer related inventions in India to be granted. So it's not that very easy when compare when we see with the other subsections to navigate to get a patent grant. So section 3K or the guideline under say CRA says like the invention which we are actually claiming, it can be a computer related invention, it can be a computer related or computer operated method with a software also, but it should have a technical effect. So to solve a technical problem, for instance, software predicting pest outbreaks that reduces pesticide usage can be claimed. So, but I mean, if there is no citation, can be claimed, and this can be a technical effect. So when to get a patent grant, navigating the section 3K objection. And the guideline also says like there should be a technical advancement. Technical advancement means to improve upon existing methods. For example, AI-based systems that make better predictions than manual scouting. If our agri software provides a tangible technical solution, it stands a better chance of being patentable. So it is too complex when we to understand technical effect and technical advancement, but yeah, it can be navigated with current technologies and with proper guidance by a patent agent. So definition of technical effect, solutions to technical problems, and examples are higher speed, maybe could be reduced hard disk access time, etc. And definition of technical advancement is contribution to the state of the art. So distinction between software with and without technical outcomes can be elaborated in the specification, and then we can actually win a patent. So these are the good examples to take. So UPI is one good example, and GPay, the founders of GPay or this transaction UPI, and which is bought by Google as GPay.
Yes, sir, sorry to interrupt you, but we are running behind the time. So
Yeah,
thank
I'll
you.
conclude. Yeah,
Yeah.
so these are the two good examples, like the computer-related inventions in agriculture can also be claimed as patents, and there is always a chance, and we are seeing like patent grants in India for computer-related inventions also. So these are the trends like I have shown. So a couple of them are like related to agri-tech also. They are filing a lot of applications, patent applications, and if you see this Sabyasachi Calcutta LLP, so they are the leaders. It's a startup. They had 710 patent applications filed. This is data till 2021. But yeah, so there are a lot of applications filed by startups, and this is a patent grant, how it looks, and the new design of the patent grant certificate. And this is one example. This person on the right side of the frame. So he's from Telangana. He filed 150 patent applications, 150 plus, which are into agri as well energy, renewable energies. So he was called for, or he was invited as a special guest for the Republic Day parade last year. So this is a photograph with the minister at the patent office, Mumbai. And what after patent applications in India? For example, if an entrepreneur or the entity wish to file in other countries, like this is the method, like there is a PCT route. within 12 months from the data filing in India or anywhere, the first application, within 12 months, they can actually think of filing a PCT application, which gives them more time to decide on the destination countries. So in total, by filing a PCT from data filing, initial filing, so they'll get 30 months time to file their international applications. But each application, I mean, separately, the applications need to be made in each country wherever the entity or the inventor wish to have a patent grant. So PCT route gives convenience to plan, reduces the cost of engaging a patent attorney in each country, because the application can be made through this route directly from the host institute or the host country, receiving country. And these are the rough estimates of different applications. I told like the application can be made in India with the government fee of around 12,000, and even you spend it by yourself not availing the scheme, it can be only around approximately 70 to 75,000 in India to file and as well get a prosecution by a patent agent, including the government fees. But not in other countries. Like these are other countries are a bit costly, and the next country which is cheapest is the US. And uh, people or the entities can consider filing in Europe as well as a one application in all the 30 countries, 34 countries. So which costs you around 4,000 euros. Yeah, that's it. Like I'll end it here, and maybe Sudhir will take it from here, discussing trademarks and other aspects of the IPs.
Yes, sir. Thank you for the insightful presentation on intellectual property, especially the clear explanation of the type of innovation, patent process, and real-life innovation examples. We believe that this explanation is definitely going to help the participants. With this, we would like to move further with inviting our second speaker. For that, I would like to invite Ms. Ushashri, manager of Manage, to introduce our speaker.
Thank you, Sonam. Good morning, one and all. I am excited to welcome Mr. Sudhir Mamilapalli, who is an expert in intellectual property rights with over 8 years of experience as a registered patent agent and IPR attorney. He currently serves as Chief Strategy Officer at 10D Innovations Nexus Foundation and is empaneled as an IPR attorney at Works Phantom IP and many top academic institutions such as Pondicherry University, NIT Delhi, and NIT Warangal. He specializes in patent search, patentability analysis, infringement analysis, freedom to operate, and IP strategy for startups. So, Mr. Sudhir is also an advocate supporting innovation protection for startups and academic institutions. With this brief introduction, I now welcome you to our 258th Saturday webinar series, sir. Handing over to you. Thank you, sir.
Yeah. First of all, I would like to thank Manage CIA and Director Sarvana sir and organizer Sonam, and a great introduction given by one of our delegate person in the Manage CIA. And sir, your Srinivas sir, your PPT is really good, and even you have enlightened us in many other areas as well. Really appreciated, sir. And now because now, Sonam, can you please give me access to share? Yeah.
Yes, sir. Yes, sir.
Yes. I think so. Srinivas sir left only trademarks for me. I'll give some insights regarding this one. Just before IPR, I wanted to make sure many people are coming to us with this choosing the legal entity, and they are coming, individually for the incubation centers. On individual basis, they are coming for. Yeah, no worries. Yeah, Because I don't know what happened. My slides are not happening here. I'll tell you.
Uh,
Many
can we
individuals are
share
coming. Yeah,
from
please,
our
you can
end,
do
sir?
that.
Yeah, okay,
Yeah,
we are
please, you can
sharing,
do
sir.
that. So many individuals are coming to the incubation center without proper startup registrations, and they're coming simply with their ideas. I wanted to suggest them better choose a proper legal entity and make your innovation more effective. Without a proper standard legal entity, if you go with some proprietorship or partnership, you will be having highest risk factors and unlimited liability. I wanted to make sure people who wanted to start their startup journey, you take care of IPR, and at the same time you have to be very cautious in choosing your legal entities, right? In this, the main normally we suggest people to go for private limited, LLP, or OPC registrations. All this comes under Ministry of Corporate Affairs, where it is having limited liability, and it is having the risk factors are very minimal. I'll give you a small example, because even there are both pros and cons when you see with this startup things. So we have to, here I wanted to focus on some negative aspects as well. Think if some bankruptcy has happened to your startup or something, how can you'll be safeguard your startup and the financials in that module? See, if your entity is if your registration is private limited or LLP, then whatever the assets you had in your current account or which is liable to your company, that is only liable. Otherwise, if you choose proprietorship or partnership, all your assets will be accountable. Even your personal assets will be accountable. So make sure when you're choosing your legal entities, uh, better go with this this one. A private limited company, one-person company, or limited liability partnership. So we call them as a directors and minimum 2 people have to be there for registering your private limited. For one-person company, 1 member is enough, but in a long run, you have to convert into the private limited company. And for limited liability partnership also, these private limited and limited liability both are somewhere.
Yeah, hello, sir. Sorry to interrupt you. Can you let me know that which slide I should put so
Yeah,
that
this is
participants
not
also have
visible.
the.
Uh,
No,
this is
actually,
slide number
I'm
12.
sharing the slide. Yeah.
Slide number 12.
Okay, okay, sir. Okay. Kindly let me know when you want to
Yeah.
change the
Slide
slides.
number 12. Yeah.
Yeah.
Is it visible? Slide number 12.
No, sir. Actually, I'm sharing the PPT.
Yeah. For
So
the
yeah.
audience, it's visible,
Oh,
right? Slide
okay.
number 12. So you
Okay.
can see here basic comparisons between private limited company versus LLP versus OPC. So when you are with your innovation or idea, choose your entity very wisely. I suggest people to go with private limited or LLP registrations. If you are with these registrations, go for DPIIT recognition certificate. Once you are done, you get that DPIIT recognition certificate, you are safe. And there is even government is giving many initiatives, right? For tax exemption is giving for 3 years. It's not that startup eligibility is coming for 10 years from the date of registration. So in this 10 years, you can avail this tax benefit any of the 3 years. It's not something in the first 3 years you have to utilize. You can utilize any of the 3 years from the date of registration to the next 10 years, right? So the as I said, better choose only private limited and LLP. In the procedure itself, you will be getting, when you register private limited, you will be getting MOA, AOA, and a digital signature, direct identification number, and name approval, incorporation certificate, PAN, TAN. If you have all these certificates, then only you are eligible to apply for DPIIT certificate. Once you get that DPIIT recognition, then people may call you as a startup. Some people were thinking that I have started in early stage, so I can be the startup. So that is not the scenario. You have to get recognized from the government. Then only people can call you as a startup. And at the same time, better you have to register your legal entity with the MSME as well. That is Udyam registration. So once you get this Udyam registration, as Srinivas sir said, you can get the benefits of IPFC facilitation support and startup support. Without these credibilities and certifications, you can't avail these facilitations and startup support, right? There and these are the things up for registrations of legal entities. And anyways, Srinivas sir has completed regarding these patents. Now I'll tell you regarding the I'll tell you the procedure, unique procedure, a single step procedure, which is equal common for all the IPR. 1 second. Can you please open slide 27? Yeah, in this, if you see trademark registration, first normally trademark search, right? So before, when you choose your brand name, you have to first go for a trademark search. Similarly, for a patent also, you have to go for patentability search, right? Here you are going for a trademark search. So people, attorneys will search your brand names with respect to specific goods and classes. Will search your brand name and will suggest you whether your brand is already existing or not. Based on the search, you can get to know whether the brand name is already existing or not. For similarly to the patent, if you do the patentability search, you will get to know whether the exact patent is filed or not in India or globally. Okay. And then once your search report saying that you can go for filing, and the next step we can go for filing your patent or trademark application. So here we'll file your trademark application based on your business activities. Clear? So here the government has given 45 classes. We'll choose based on your business activity. We'll choose and guide you which class it will comes under. 1 to 34 gives under goods category. 35 to 45 is coming under service category. So after filing your application, what will happen? The government will scrutinize your application whether there is any objections or not. If any objections has happened, they'll intimate us by giving the examination report. Similarly, for patent also, they'll give the first examination report. Here we call it as an examination report in objection. For patents, we call it as a first examination report, right? So based on the report, we do legal citations, and based on which sections they had given you the objections, we will verify and will draft the reply. Mainly the objections comes under section 11 and section 9. Mainly section 11 deals with, the similar trademark has been filed in India earlier, and for for patent they'll focus mainly on novelty, non-obviousness, utility criteria, as sir has already explained to you. So based on these 3 criteria only, mainly they'll focus and they'll give the first examination report for patent. Okay, if no objections were there and the initial stage itself, your application will get accepted, right? So once after acceptance, government will publish your things in journals, trademark journals. So for patents, that is not the scenario. Even without examination also, it will get accepted. Not accepted, it will published in the journal, right? So once after published in the journal for trademark, people can file an opposition. Normally there might be some scenario, because it's a kind of a perspective how the examiner look into your application. The examiner may think that your brand name is eligible for grant. He can accept your application, but the competitors who think that your application, your brand name, which is similar to their brand, definitely there is a chance they can file an oppositions. So now again, for this opposition, again we have to start working on the opposition, where we have to, for the notice of opposition, we have to submit the counter replies, and then evidence we'll get, and again we have to submit the evidence, and hearing will happen, and finally, based on the merits, the trademark registry will take the decision whether to approve it, the application, or accept or refuse. The main hurdle we face as being an attorney is we, based on our expertise, can guide our clients to tell the possibilities of getting registration of patent or trademark. But we are not, we cannot say that 100% assurance. So based on your attorney expertise and reliability, you have to choose your attorney wisely. And at least some people won't listen to the attorneys as well, but at least you have to trust your attorney based on your things happening. So because we normally, we give the examination report to the client, and we'll explain in detail to each and every aspect, and will make you comfortable, and will make you understand each and every point. And what are the government schemes available, will apply to you, and things can get benefited. So this is the similarly for patents, trademarks, copyrights, all the procedure was same. One is filing, objection, hearing, which revolves under these 3 stages. Yeah. So, and one more thing regarding the trademark, if you see anywhere the TM symbol, we call it as a trademark has been applied. If it is R, then the trademark has been registered, right? So I wanted to, conclude with a quote. If you don't build your dreams, someone will hire you to build their dreams. Some of the famous quotes said by people. Yeah, I want to thank you for giving me this opportunity because I want their audience to ask their queries as well. Thank you.
Yeah, thank you so much, sir, for your detailed presentation on navigating the startup and IPR ecosystem. We especially appreciate your clear explanation of trademarks, how they help build brand trust and provide exclusive rights and offer protection, which is very useful for startup to protect their brand identity. And so now we will move to the Q&A session. So I request all the participants to post your queries in the chat box, or you can raise your hand and we will unmute you so that you can ask your question directly to the speakers. So I will start taking the question from the chat box. So Mr. Rakesh is asking, good morning, sir. Rakesh this side. My question is, since the most agri startup face financial constraint in their early stages, what affordable strategies or government schemes exist in India to help them register and maintain their IPR?
So
Anyone
normally,
can answer? Yeah.
yeah. So in my perspective, there are many incubation centers were out there, and there are many cohorts were happening, and you have to just look into the every year. If you see throughout India, DST has sponsored many incubation centers for not only for agri-tech, they're based on the thrust areas. You can find many incubation centers based on your region. You better in your state check for incubation centers, go there and give your presentation. If you're having your invention is having the best potential, definitely there is a chance we get initial idea stage of funding. And even you can participate in hackathons which we are conducting by MSME. Incubation centers were there in many educational institutions. You can even recently happened idea hackathon 5.0 is done. Similarly, there will be in the next phase in next year there will be another hackathon. You better participate with your ideas and everything, and choose any incubation MSM incubation center in your region and apply it. And there is a best chance they are giving 15 lakhs rupees fund for your idea at the idea stage itself. Okay, so that's my best suggestion for you on this.
Srinivas sir, you want to add something in this question?
Yeah, we have IPFCs. We know MSME IPFCs in Telangana. We have 3 active IPFCs where the government fee need to be paid by the applicants, and the professional fee, like they'll take care of the filing and prosecution of the applications for all patents, trademarks, designs, copyrights, and as well GIs. So we have 3 IPFCs. One is under NIMSME, NIMSME at Yusufpura. One is at OU Technical University, Technical College, OU City. And one is in Warangal, Vagdevi College of Engineering. And we have NRDC IP Facilitation Center in Vizag for Andhra Pradesh, and as well, the whole of India actually, NRDC centers. So we have one in Delhi and one in Vizag. These are nodal offices where the applicants, even NRDC IPFCs will support individuals as well. There is no need of actually need to have an entity to file their IPs. So even natural persons, male, female, irrespective of their qualification, age, creed, so they can actually write to NRDC center at Vizag or maybe Delhi. So seeking IP facilitation under the scheme, like again, that will be directed to a facilitator under the Startup India facilitation scheme, which like IPO hosts the funding. Means like IPO will pay the patent agents or the trademark attorneys who are all the patent agents and all the trademark attorneys. There is no special empanelment, so it is there for Sudhir. Sudhir is also eligible. Myself, I am also eligible. Means like anyone out there, and a startup or a small entity, like with startup mostly, like it works under SIPP. But if they are not startups, like it's an MSME, then if it is Telangana, like we have 3 IPFCs here, like in Gujarat, there are IPFCs under SSIP 2.0 for even students and natural persons and startups. in each state, like there are IPFCs under both MSME and National Policy of Startup India. Apart from that, like we know, Manage also used to, I mean, is also an IPFC, right? So you have empaneled facilitators, where like obviously like where facilitation means like you don't need to finance from a Manage, but you can direct one under the SIPP scheme or one under the MSME IPFC. So that means any natural person, any startup, any small entity, it can be proprietorship also into agripreneurship under Manage without being incubated anywhere also, they can get aware these schemes.
Yes, sir. So I can see Wazid raise his hand, so I kindly unmute him. Kindly unmute Wazid. I request my team kindly unmute him, please.
Hello.
Yeah, please go ahead with your question.
Yeah. Good morning to all. Just I would like to thank Srinivas sir because I am the one of the client for the EVA services. We had the 4 trademarks registered through EVA services. I really appreciate Srinivas sir and their team. Really proper guidance were given, no tensions at all. But only the thing is, sir, my question is, while the registering the trademark, so when we promote or when we advertise, when we get the actual registration after 1 month or 6 months, it depends on the duration based on the file or the processing. So when we start using that trademark as a TM, trademark register, trademark in the brackets, so when the objection raises, any objection raised, so we were afraid whether we were in legally prosecuted or like that. So it's like too much time taking for that. So anything like shortcut or any express tatkal scheme for minimizing that this duration, is there anything is there, sir?
Yeah, we have expedited examination for trademarks. Likewise, in patents, we don't have in design, but trademarks we have expedited examination, but it is too costly. Why I'm saying is like the application fee for a small entity or a natural person is 4,500 and the expedition is 20,000 additionally. So in the initial stage, for example, if you are filing now, means during the application filing stage, like if you are expediting, means like that spending of 20,000 is justifiable because you'll be saving 1 year time at least with the expedited examination. But if you are expediting after example, like you already filed an application and it is like almost 1 year and it is now in under objection, then there won't be much use with the expedition. So if you want a brand registered to be registered very soon, then expedited examination along with application is suggestible. At a later stage means like it is already into prosecution and it is almost done, or it only takes another 4 to 5 months. So in that case, like expedition is not suggestible.
Thank you very much, sir. That's all.
Yes, sir. So next question is from Mr. Ashok. Hi, Sudhir sir. There is a little confusion about registering a legal entity between LLP or private limited. For a single founder like me, how would it cost range, sir?
Okay, for a single founder, normally we recommend to go for a OPC, even though if the OPC means one person company. Even if you are registering your entity with one person company, definitely you should have a nominee with you. So you choose for any nominee, and even if you register your entity with OPC, private limited, after a couple of years, you have to transfer your OPC to the private limited. So if you don't want to add others, but still you have to add one more person, and you can make yourself 95% or 97% shareholding with you and just keep 3% shareholding with the other person and make your entity strong.
Yes, so I will take few more questions because we are running behind the time. So there is next question from Mr. Santosh. My doubt is whether it is better to apply for copyright at the proof of concept stage on an app
when it is not fully developed or after the app is well developed? What is the right stage to obtain copyright? Also, if I register the copyright during the POC stage using the app source code, can I later make alteration or modification to it?
Yes, Sudhir.
Yeah. So here in this, in my opinion, see, if you're not ready with your code, better go with at least there will be some UI designs, right, with you. At least go for getting cooperate with your designs first, and once you're done with your source code, and then you can go for your source code copyright.
Yes, sir. So next question is from Mr. Sandeepan. Greetings to the speakers. Can we patent source code or the app interface? And in IoT, which parts we can patent except the boards? Can we patent the design of the machine and its workflow?
He has asked me 3 questions in a single message, I guess. You can go for a copyright and for a patent as well. Madam, what is his name? I just wanted to.
Yes, sir.
Question.
Should I repeat the question, sir?
Yeah. Can you please?
Yeah. Can we patent source code or the app interface? And in IoT, which part we can patent except the board? Can we patent the design of the machine and its workflow?
So for the paid source code, we have to go only for the copyright. And if you have any interface, there is a chance you can go for a patent. And for your designs, you can go for a design patent. So you have to go for copyright, utility patent for your interface, and the third one, design patent for your machine. Design.
Yes, sir. So, and next question is, are desi seeds patentable?
Are
desi seeds are patentable? This is the question, sir.
Okay.
It comes under traditional knowledge, so, or known thing, right? So obvious it is, when seeds itself cannot be patented. So it is as per Indian Patent Act. But in some other patent acts, like in US, like you can patent a modified seed variant. So in India, we cannot patent. There is a prominent case, so with which like they related to cotton, so we know it. So
yeah,
we cannot patent seeds as such.
So some BT cotton is there, some genetically modified seeds. Yeah, we cannot go for a patents.
Yes, sir. So we are now close to the end of this session. So if you have any further queries, you can directly contact our speakers. Their contact details are available in the chat box. And also, I would like you to inform you that we have recently launched the 9th batch of our pre-incubation mentoring program. If you are an inspiring entrepreneur, this program is for you. For more details, please visit our website and follow us on our social media pages. And before wrapping up, I would like to thank both the speakers and all the participants and our director, Dr. Sarvanan Raj sir, the Director of Agriculture Extension and CEO of Manage CIA, whose vision made this 258th webinar possible, and my team who organized this session smoothly. Once again, thank you so much for joining. Have a good day ahead. Thank you so much, sir.
Thank you very much, sir.
Thank you.
Thanks
Thank
for the
you.
team. Thank you.
Thank you, sir. Both of you are joining. Thank you very much. It's nice to listen to
Thank
you.
you.
Thank you very much.
Yeah. Thank you, sir.
Thank you.